এর কাছ থেকে একটা তাহলে কপি নেওয়া যেতে পারে আর কি, নোটিশ অফ মোশনের কপি। যদি কল করুন, হ্যাঁ, তারপরে দেখছি।
Lordship, may I be permitted to mention one application for correction of Lordship order dated June 11, 2025, Lordship. In this order, Lordship allowed the application there be an order of in terms of prayer number A to H, but instead of A to H, that should be A to L. Lordship,
Okay, you let it appear as to be mentioned
grateful.
on Monday.
Lord,
Serve notice upon the other side.
Lordship, none appears for the other side, Lordship.
Okay.
Every service has.
Lord, I have also this similar prayer, Lord. Your Lordship has passed an order on 22nd of May 2025, Lord, restoring this suit. Lord. It was dismissed for default.
Yes.
I was defending this suit, Lord. But Lord, I was representing Lord, phone number of defender number Lord, say 16, Lord.
Yes.
But by wrongly Lord or something like that, Lord, there is written Lord, my representation was 16. So, Lord,
1/6 you are representing.
yeah, Lord,
Anyway,
I am representing 16, Lord.
but it was recorded as what?
17, my lord.
17.
So,
Okay, let it appear as to be
my
mentioned.
lord, only. Upon notice, I am mentioning this, my lord. Grateful to you.
To be mentioned, item number 1.
Your Lordship, I am appealing for the plaintiff.
Yes.
For the defendant in this matter, Your Lordship, on the last occasion, Your Lordship had directed that the matter will appear on the 30th of June
Yes, Your
and
Lordship.
the department will file a report.
Yes, in this matter, yes, this matter was sent to the register for assessment of the stamp duty.
Yes, yes, Your Lordship.
Anyway, the question is, the matter was sent to the collector, but the report has not come.
Yes, Your Lordship.
So it is due to appear on 30th.
30th.
Yes. Yes, Your Lordship.
So let it appear on some other date. Instead of, 30th June it is due to appear.
Yes, yes.
So let it appear. In the meantime, if the report comes, it will be put
I
up.
do not know at whose instance it has come up as to be mentioned, Your Lordship.
Yes.
Let the matter come up on the 30th
Okay.
of June.
Let it appear on the. Let this matter appear on 30th June 2025.
Great.
Orders, item number 2.
এইটাতে দেখুন নোটিশ অফ মোশনটা কপিটা আছে কিনা।
This was my application.
This GS 601147.
Yes.
1947. Yes, your petition is allowed, but the question is, the notice of motion is not in the record. That is the thing. If you have a copy, please.
Yes, yes, of course. I'll just hand it over. Notice of motion এখানে দিয়ে দাও না। But I'll not hold your lordship back, Lord.
Anyway, I'm just passing the orders.
Very well. হ্যাঁ, তাছাড়া application ফাইল হবে কি করে? Notice of motion ছাড়া কি করে application ফাইল হবে? আমার তো কপিটা নোটিশ অফ মোশন থাকবে না, নোটিশ অফ মোশন It's a notice of motion. That I have the notice of motion.
You don't have,
I have.
you have it. Very well.
It's in green, Lordship will just. But this is the notice of motion. It must have been there on the record. Without it, the application could not have been filed. But this can be retained with the records.
Yes, there will be an order in terms of prayer A, B, C, D, E and F of the notice of motion. So I'm fixing a date for submitting the report of the sales.
Mine.
Let this matter.
But you can dispose it of,
No, something, you see, there are some prayers, you see, regarding investment and all these things.
That the trustees, that the Shevites would do.
That is
I-
agreed with the Shevites in the decree.
I don't think I need to trouble your Lordship with it
Okay,
anymore.
up to F it is allowed, okay?
No,
Well,
in the decree it is stated that the Shevites.
আমি ট্রেডগুলো পাচ্ছি নোটিস অফ মোশন দিয়ে দিয়েছি No, my lord, your lordship will allow G also, my lord. G and H. Because otherwise when the money comes, I would want to invest that for the application of the
But for
DT.
this, you see, some scheme should be prepared, some.
Scheme is already there. Lordship had passed
It
the
should
decree
come
way
before
back.
it should come before the court, or a special officer should be appointed to discuss and direct to appoint a
In
scheme.
the decree, this is by the decree, the scheme was framed in respect of the Devotta.
No, after the sale, regarding
After the sale, well, I am selling my portion, which your lordships have delineated in 1950s. Now that's why I am praying prayer G. So if I sell it, I will have to invest it for the application of the DT.
okay, so F and G.
G and H also, my lord. Because this is also for the benefit of the DT.
Okay.
And we've given a bunch of orders on the last occasion. Your lordship will find such orders have been passed even before. But I sell it in the name of the DT because the DT is a perpetual
No,
minor.
regarding investment, because
I put it, which is why I'm praying for your lordship to allow G and H. Your lordship will find a specific prayer is only for the application of the DT.
no, definitely.
Otherwise, if your lordship does not grant me that, then I'll take the money and we can do something. So
No,
G
no,
and H is important,
That means, you see, that has to be kept in a specific account.
which is why G and H.
Yes.
To
specific-
invest the balance amount consideration for the DT's application.
Then shall I fix a date for report of the investment?
No, your lordship can just dispose it of.
Okay.
Had there been anything, my lord, I would have told your lordship. There is nothing.
Yes, I'm recording copy of the notice of motion. File be kept with the record.
Yes.
Yes, it is disposed. আচ্ছা এটা রেখে দিন। এটা কি কারণ আর তো নেই নোটিস অফ মোশন, তার মানে
Certified copy of the order. Urgent.
yes, if it is traced out, it will be returned.
That is all right. It can be retained. Not a problem.
Okay,
Great.
Sign copy টা নিয়ে নাও, আমরা seal করতে
That's one request.
yes.
It will be your lordship's pleasure to just, whenever your lordship is passing the order, that the parties would act on the basis of the server copy that is there.
Okay, that will be recorded.
Fine.
Huh? No, disposed.
Obliged, your lordship.
Great.
ওটা একটা তলায় একটা আমি হাতে লিখে দিয়েছি ওটা। আমি অর্ডারটা আমি রেকর্ড করেছি, করে ওটাকে এক লাইন লিখে দিলাম, নোটিস অফ মোশন বি কেপ্ট উইথ দ্য রেকর্ড।
Item number 3,
My application.
Yes, this petition is allowed. Let there be an order in terms of prayer A of the master summons dated 17th day of February 2025.
I'm so grateful. My lord, PLA 115 of 1997 has to be, my lord. Accordingly, my lord, the probate granted in terms of this PLA, my lord, has to
Yes,
be.
yes, this in this PLA, this is order is passed in PLA 115 of 1997.
Yes, my lord, in my application, which is
So
GFO.
any reference will always be with reference to PLA 115.
So grateful. Deeply acknowledged.
Ye disposed.
Item number 4,
And for the plaintiff, my lord, that modification matter, decree modification.
In this matter, the question is, apart from filing the petition, did you submit any written notes?
No, my lord, we have not submitted. Lordship so desires.
No, because you stated that you shall rely upon some authorities on this.
No, my lord, not on this matter, my lord. This lordship, I was perhaps able
Because
to
this is
convince.
commissioner's report, whether it is
Yes,
to
my
be,
lord, it should
whether
be
your review application will be allowed
Yes,
or not.
modification application.
Because you stated that some authorities will be cited and some, so
My lord, on the last occasion, lordship has heard me extensively.
probably earlier you stated that
Yes,
some
my lord,
authorities
and
will be
lordship was
cited.
convinced that perhaps that portion has to be read into the decree.
Anyway, then let me pass an order. And the special officer is already appointed in this
Yes, my
matter.
lord, he has been discharged, my lord, after he has filed his report, my lord. He was not exactly the special officer, but he was the partition commissioner, my lord. Commissioner of partition. He had already submitted his
Now the
report.
question is,
Yes,
after disposal of the disposal, allowing your application, somebody has to be appointed.
my lord, we had prayed for prayer B, my lord. Let me abreast your lordship of a incident, my lord. On the last occasion, we had held conference, and we have come to know that the defendants, except 5, 6, and 7, have already executed deed in favor of the plaintiff because they are all co-owners, my lord.
Anyway, it is not a part of your record.
My lord,
It
if
is a subsequent incident.
Yes, my lord. They have already executed. So, my lord can restrict the order in terms of prayer B, my lord, which is our prayer now, that since the defendants are not appearing before your lordship in spite of notices even from the department, my lord, so prayer B be allowed. My lord, prayer B was to the extent that since if they do not execute the deed of conveyance, then the learned registrar be directed to execute the deed, my lord. So now we are pressing prayer B, my lord, and kindly restrict the prayer B to defendants number 5, 6, and 7 because they have not executed the deed, my lord. That is my
So
humble.
whatever is there in your prayer, that has to be prayer B.
Yes, my lord. The erring defendants, so far as erring defendants are concerned, lordship takes care of them and grant us prayer B restricted to 5, 6, and
Yes,
7.
record and order. Let this matter appear. July 2025 for orders.
My lord, so far as the other defendants, my lord, I have shown that part of the partition commissioner's report where all the parties were addendum so far as sale of their respective shares in the
So
property.
you have confined yourself to
only
prayer
to
B.
5, 6, and 7.
To prayer B.
Prayer B and to defendant numbers 5.
Anyway,
6,
whatever is there in prayer B, that will be
my lord,
considered.
prayer B, when it was drafted, my lord, it encompasses the entire realm of defendants.
No, but have you incorporated by way of supplementary affidavit? Because
If lordship so desires on the next day, we shall file a supplementary.
or I can allow this prayer B.
Yes, my lord. Prayer B.
Your purpose will be served.
Yes, my lord. Kindly clarifies that it is restricted only to 5, 6, and 7 because the others have already executed the deed.
It is there in your petition?
No, my lord, it's not there. Then I shall file a supplementary affidavit. Kindly fixes the matter.
Then it's better instead of passing orders, then let me fix this matter for filing supplementary
Yes, my
affidavit.
lord. Yes.
Yes,
Kindly.
record an order.
Yes, sir.
Let this matter appear on
Kindly takes it up next week, any day.
Monday,
Yes.
30th of June 2025, under the heading to be mentioned. Okay.
Obligation.
Target কেটে দিন তাহলে. Yes, next.
11 matter, fixed matter.
Yes, 11.
এটা fixed at 11. Adjourn motion, item number 7.
Defendant number
My lord,
128.
Mr. Shiv Shankar Banerjee is appearing online. My lord.
Yes, my lord. My lord, I am appearing virtually, my lord.
I am for 10 to 12, my lord.
So this GA7,
GA7, my lord.
yes, you are for the plaintiff.
I'm for the plaintiff, my lord, led by Mr. Shiv Shankar Banerjee, my lord, appearing online, my lord.
No, all the parties
My
are
lord, in this matter, everyone was ready for a preliminary degree, lordship. Based on an admission that the share or the percentage of the share is confirmed by all. GS7, lordship.
Page 90.
yes.
So, lordship, then the written statement which was filed by them, I have also annexed annulling my application. So, lordship can pass on preliminary decree based on the admission of the parties.
So no opposition is filed to this GA.
Lordship, opposition reply, everything fighting, everything we have admitted.
No, GS
Admitted.
GA7 so far as defendant numbers 10, 11, and 12 are concerned, we are agreeable to it.
Yes. So
There is no question of
who has filed opposition to GA7?
Nobody filed, my lord.
Nobody has filed.
Nobody filed.
No more.
Yes, record an order. Learned advocate for the plaintiff and learned advocate for, you are for
10
defendant
to
number
12. We are both 10
10
to
to
12.
12
1 to 8.
and learned advocate for defendant number 1 to 8 are present. Learned advocates have made their submission on GA7 of 2022. That appear for orders on 3/7/2025.
3rd of July.
3rd of July.
Huh?
3rd of July.
July. For orders.
না এগুলো নেই
Yeah,
আচ্ছা
ঠিক
এইগুলোকে তাহলে ঠিক করে রেখে দিন এটা
If your lordship kindly record, if your lordship kindly also records that all parties have given consent for this, so that on 3rd July we again don't have to call for every advocate. Anyone can appear and can
that day the application will be disposed, orders will be passed. You don't have to submit anything on that day.
Lordship, I'm deeply.
রেখে দিন এটা সব নোটিশ একসাথে করে চেম্বারে পাঠিয়ে দেবেন
Item number 5.
My lord, I appear for the plaintiff. My lord, this is application filed by the defendant after 6 years for discovery of documents. The
GA6.
yes, suit is
GA6
ready.
also affidavits are ready.
I have filed affidavit. They have not appeared for the last 2 days.
Extension of time was filed for
After 6
discovery
years.
of documents, my
My
lord.
lord, kind.
And for that,
No, this GA6 is for what?
for the discovery of documents.
After 6 years,
And my
after
lord,
documents discovered 6 years back,
we-
it is ready for hearing.
Let me
Now
see.
they are coming.
my lord, we could not file the within time, my lord, so we prayed.
No, GA6 is your application.
My lord,
Yes.
my lord, we
Let me see
we
the
filed an
application.
application for extension of
We
time
have
for
filed an
production of
affidavit
documents.
in opposition.
They filed an
You have filed affidavit.
Yes, your lordship had directed me. They did not appear on the last 2 occasions.
17th of June, we received via email, my lord. The affidavit in opposition will be needing time to file a reply.
Let me
This is
see.
just, my lord, dilatory tactics, eviction suit of menial employees of DT. It's a Shebait's suit. File. No defense, no money paid, in occupation, wrongful occupation for 10 years, no defense. After 6 years, they are praying.
Give the petition GA6.
Property belongs to the DT. It's an eviction suit filed by the Shebaites for unauthorized occupation of two persons who were ex-employees of the estate of the DT. Wrongful occupation for years, nothing paid. Documents were discovered in 2018. I discovered my documents. I wrote them a letter saying you take inspection, you disclose. They did not do anything since 2018. After 6 years, they're coming out just to delay the hearing of the suit. Suit is ready for hearing. I filed my judges before documents.
Issues are not yet framed.
Issues are not yet
But a week's time may be given to file a reply, my lord.
Just file out directly. No explanation why they could.
That is my instruction, my lord. Kindly give us week's time. We will file the reply.
Just, my lord, dilatory tactics.
No, you, by your letter, granted them opportunity in 2018.
Yes. Since 6 years, they have done nothing.
Any reply given to the letter?
No, nothing.
No, so far their documents are concerned, you have also not taken any inspection?
No, they have not disclosed. Kindly see, I have mentioned in my affidavit.
Yes,
they did not do anything. Affidavit, Parate, the advocate on record, being the appellant herein, have neither took any steps to inspect the plaintiff's document, not took any steps to file the documents relied upon.
They have not filed their documents.
Yes, after 6 years, they are doing this. When the suit is ripe, ready for hearing. I will beseech your lordship, kindly do not, my lord, allow this show any indulgence.
Just a 1 week time, my lord. To file a reply, my lord. We'll file a reply, my lord.
এটা দিন GS6 টা
But kindly have a look at my affidavit in opposition. I have stated the entire facts.
GS6 টা আসেনি এর উপরই করতে হবে, দেখতে হবে। ঠিক আছে, আমি আজকে করে দিচ্ছি, অর্ডার করে দিচ্ছি। Did the defendant rely on any documents in their written statement?
No, nothing. And nothing stated. They have to say why they couldn't. Nothing stated.
My lord, kindly give us 1 week's time. We'll file.
Please let me go through your petition.
Oh. In para 3, they have stated not available. That is not good enough. They'll have to say why it was not available for the last 6 years and why it is available after so many years. No explanation. They have to give a justifiable reason why they couldn't file in 2018.
When was this application filed? This GS6
is filed in 2025.
So have you obtained the documents?
But, we are also filed an application for extension of time to produce the documents.
No, very well. Suppose you cannot get the documents by 6 months.
No, but kindly give us just
6
1
months.
week's time. We'll file the reply and we'll deal with all the.
No question of reply. When can you come ready with the documents? You have to come ready. Suppose you ask 6 months time to find out the documents. So that will be granted to you.
My lord, kindly
They have
do
filed an
not
opposition for.
give any further indulgence.
They
My
have
lord,
filed an
for
opposition,
6
my lord, you
months
have
they
to
have
file a
done
reply.
nothing.
No, you are. I am considering. I am keeping aside his objection. I am considering your
Then
petition.
can give us 2 weeks time, my lord.
That means 2 weeks you will get yourself ready with the documents. You will take his inspection as well as you will disclose the documents.
At least give us 2 weeks time. We'll try to do that.
There is no explanation why they couldn't produce. They have to give explanation that why they were not in a position to disclose the documents in 2018. Nothing. Just two words is not available, is not good enough. And kindly see the suit. Years in occupation without paying anything, creating obstruction in the Seva Puja, hauled up for contempt, apologized before court. Justice I.P. Mukherjee was sending them to jail.
Yes, record. Learned advocate for the plaintiff and learned advocate for the defendants. Defendants are. You are representing both the defendants are present. The affidavit in opposition filed in GA6 of 2025. Have you filed the opposition already?
Yes, yes.
আচ্ছা তাহলে ওটা কেটে দিন না এটা তো অপোজিশন ওদের পিটিশনটা আচ্ছা এটা অপোজিশন রাইট let the affidavit in opposition filed in GA6 of 2025 be kept with the record.
That order is already there. Your lordship has already kept it on record on the order date.
আচ্ছা ওটাকে কেটে দিন তাহলে
13 May. Kindly see this order.
তাহলে ওইটুকু রাখুন learned advocate for the plaintiffs and learned advocate for the defendants are present. The application GA6 of 2025 is taken up for consideration. Stop. Hard learned advocates. It is the contention of the defendants applicants that they cannot participate at the time of discovery of documents due to non-availability of some vital documents. But the said documents are found recently. Stop. It is further contended that with regard to a particular police case lodged against the defendants, the depositions of the said case is important to rely as in the instant case, thus some time be granted. Such contention is opposed by the defendants on the ground that for the last 7 years, the defendants were silent and did not take any steps to disclose the documents, nor did the defendants take any inspection of the documents of the plaintiff. It is further contended that the defendants have filed this application with the intention to delay the matter. Stop. Upon hearing the learned advocates and considering the facts of the case and the contention that the defendants have recently traced out the documents which are required, this court is of the view that as right to defense is a basic right, some reasonable opportunity should be granted to the defendants to disclose the documents as also to take inspection of the documents. Thus, the defendant is granted the last chance to take the inspection of the documents of the plaintiff as well as to disclose the documents within a period of 4 weeks.
2 weeks, my lord. He prayed for 2 weeks, my lord.
Okay, I'm just making it 3 weeks, subject to the payment of costs of 100 GMs to the plaintiff within the said period. No, within 1 week. Upon completion of the discovery and inspection, the matter may be mentioned by the parties. So within 3 weeks, this
Exercise has to be
complete and subject to the payment of costs within 1 week.
Kindly
My
take
lord,
the deposit cost.
let it appear after 3 weeks. Let them show.
Okay.
Let it
Let
appear.
the matter
Yes.
appear on okay 11/7/2025.
Very good. I'm obliged.
Kindly done the deposit cost, my lord. Kindly, my lord.
Yes.
Kindly done the deposit cost, my lord.
No. There's enough delay. But pay the cost within 1 week.
Great. Thank you.
Adjourn motion, item number 6.
My lord, this is my application. My lord, in a partition suit, preliminary decree had been passed by consent of the parties. Several years have gone by, final decree could not be passed because certain obstructive stand taken by some of the defendants. This is an application taken out by the plaintiff, the defendant number 1, the defendant number 3, the defendant number 4, and the defendant number 5 to pass a final decree in terms of the preliminary decree. The other defendants, my lord, who are opposing, have been kept outside the scope and ambit because we are saying that we are praying for this final decree in accordance with the terms of settlement which has been filed, which ultimately culminated in the preliminary decree. My lord will kindly take
What is the preliminary decree?
Yes. My lord, the preliminary decree is on page 52. Yeah, preliminary decree to it enough. পড়াই যাচ্ছে না। পড়াইতে যাচ্ছে না। সেটা কোথায়? My lord, kindly come to page 15.
Page
15.
15.
Yes.
Yes.
The preliminary decree was passed on the basis of this terms of settlement. No. All the parties are arrayed as parties, my lord, in this preliminary decree, which is part of the terms.
You're the part of the terms of settlement.
Yes. Now, my lord, initially, my lord finds the prayers. I shall have to place this preliminary decree, my lord, in detail to show your lordship what went to whom. My lord, kindly come to page 19. Whereas,
yes,
the parties to this family arrangement are co-sharers, co-owners in respect of various properties situated at Kolkata, which were owned originally by their predecessors, so and so. That the said properties as more fully described in Schedule A, except one situated at Queen's Park, are all let out to different tenants, and income therefrom, after deducting the expenses, are to be shared amongst the co-sharers as per their respective undivided share as more fully detailed in Schedule B. Parties have agreed that without prejudice to the contentions of the plaintiffs, it shall be deemed that the property Queen's Park belongs to parties of the 4th part and parties of the 5th part. So Queen's Park, my lord, is sorted out. It goes to the parties of the 4th part and the 5th part. That in the course of the maintenance of the joint properties, disputes arose between the co-sharers, as a result of which the parties of the first part as plaintiffs had filed a suit for partition, being suit number so-and-so in the High Court at Calcutta, against parties of the second part to parties of the 5th part, the defendants, which is in the pending application. That during the pendency of the suit, the defendants, being parties to the second part, parties to the fifth part, represented by Aftab Anwar Baker, approached the plaintiffs for an amicable settlement of the dispute, to which the plaintiffs, represented by the constituted attorney K. Jabbar, agreed, and whereupon the parties to the proceeding decided to partition the properties as mentioned in Schedule A hereunder by metes and bounds according to the respective shares mentioned in Schedule B, and the parties have agreed that their allotted portions, including the right to collect proportionate rent, will be enjoyed by them as absolute owner thereof. So, my lord, the shares are agreed to, the properties are agreed to. Now, this family arrangement witnesseth as under, that the parties as at the proceeding being title suit number 194 of 2010 pending before the Honorable High Court at Calcutta are holding undivided shares in respect of the joint properties mentioned in Schedule B hereunder. That till now, it has all along been agreed that the first defendant and fourth defendant shall jointly, in the name of Messrs. AC Estates, collect rent from the tenants, and upon disbursement of all expenses, shall distribute the profit among all the parties in the ratio as per Schedule B. That without prejudice to the contentions of the plaintiffs, it is hereby agreed that property of Queen's Park shall be kept out of this partition, and the same shall be deemed to have been belonging to the parties of the fourth part and parties to the fifth part absolutely and forever by virtue of the gift made in their favor. Now these parties have amicably settled amongst themselves their respective shares in the said property and agreed to demarcate the same as mentioned in Schedule C. That the joint properties thus partitioned by metes and bounds shall be subject to the order of the Honorable High Court that may be passed in title suit number so-and-so on the basis of a compromise petition, and this memorandum of family arrangement shall be presented before this Honorable Court to form a part of the decree. That both the plaintiffs and defendants shall cooperate with each other and render all possible help to obtain the consent decree on the basis of the memorandum of family arrangement by filing a compromise petition. That cost to this compromise petition and all expenses in connection therewith shall be jointly spent by the parties. Next page, that the parties from time to time, at the costs and expenses and on request of the party requiring, do execute and perform all such acts and further acts, deeds and things for further assuring the respective allotted portions respectively allotted to the parties. The respective parties shall be entitled to income of the said properties in respect of their respective shares and also bear and pay all expenses and liabilities of the future in respect of the said properties. Well, 10, that the respective parties to whom the respective shares and allotments have been made under this deed shall peaceably hold and possess the same without disturbing others' allotment absolutely forever. That each party shall enjoy, sell, transfer, convey, or otherwise use, put to use the said properties going to his or her share, but subject to right of preemption of any of the other co-owners. That each of the parties hereby agree that he or she has no right, title, or interest in any other claims made. So, my lord, this is the settlement. My lord, clause 4 is very important because it refers to Schedule C. Now the parties have amicably settled among themselves. My lord, clause 4 is on page 21. Now the parties have amicably settled amongst themselves their respective shares in the said property and agreed to demarcate the same as mentioned in Schedule C. Now, what is Schedule C? Kindly come to page 29. My lord, bottom right hand. The area allotted Schedule C to party of the first part. So this is the area.
Bottom of page 29.
29, right hand side, bottom. Well, this concerns 6 Western Street, Engineering Center. And my lord, the shares are worked out over here. Rabia, as your lordship sees, gets 35.483%. Lathit gets plaintiff number 2, 29.033%. Zahir, plaintiff number 3 gets 14.19%. Zafira, plaintiff number 4 gets 7.08%. Zamina gets 7.09%. She is also a plaintiff. Plaintiff number 5, and Zabida, plaintiff number 6, 7.097%. So far as Schedule C is concerned, and the property at Western Street is concerned, your lordship sees
Western Street, this is not in this chart, but it is in your petition.
No, it is there on the left-hand side.
Left-hand side is
6. My lord, here.
Oh,
in
6
this-
Western Street.
Yes. 6 Western Street. All the properties, my lord, are mentioned separately on top. Left-hand side.
And the
Bentic
left-hand
Street.
side is this. These are what? Tenant.
Yeah.
Dastur? Tenant.
Yes. That is immaterial right now.
They are under occupation.
Yes. But the fact is, 6 Western Street has been allotted to the plaintiffs. And the other properties, if my lord goes to the top left-hand side, there is Bentic Street, 71 Bentic Street, Faraday House. My lord has seen it. It goes to Aftab Anwar Baker, defendant number 1.
Yes, that is
Then-
second part.
Yes. 72 Bentic Street, AC Mansion.
Yes, second part is C2.
Well, look, that is in relation to the other buildings. Today, my lord, I'm concentrating on Western Street, the plaintiffs, which your lordship has seen under schedule.
So this Rabia, Latif, these are all plaintiffs.
All plaintiffs. All
Of
plaintiffs.
C1, schedule T1.
Yes.
Yes. Now C3, now C2 is this.
Only instead of Rabia, my lord, Fehmida has come because there has been a death.
And substitution is made.
Yes, yes. The cost title has been changed. The cost title is Fehmida.
And
Now,
he has-
what has happened thereafter? Now, what is happening is, although, my lord, this particular property has been earmarked for me and given exclusively to me, I am not concerned about the other defendants or the other properties that have gone to them.
Now regarding 51.93, this is Aftab.
That is defendant number 1. That is
C2.
defendant number 1.
Defendant number 1.
Yes. Different premises. I am not on Bentic Street property. I'm
Okay,
only on
you are
the
confining yourself to 6
Western-
Western Street.
6 Western Street.
Yes. And as per the terms of settlement, this 6 Western Street property
Yes.
is to be
Comes to the plaintiffs only.
as per their shares.
Yes. Yes. If my lord sees page 24, it will become clearer because the printing is clearer here.
Page 24,
Schedule A,
Schedule A.
there are 4 properties.
Yes.
71 Bentic Street, 72 Bentic Street, 73 Bentic Street, and 6 Western
So you are
Street.
concerned with D,
Yes.
6 Western Street.
I am concerned only with 6
Yes.
Western Street, D. And Schedule C, how it has been demarcated, my lord, and allotted, has also been given in the bottom of the page at page 24. Which is, of course, my lord, given in further detail on page 29, which I have just placed before your lordship. And their shares, my lord, page 30, in terms of C, but I'm not taking your lordship to that. I'm interested only in 6 Western Street.
That is page 29.
Page 29, and that 6 Western Street forms part of the 4 properties which are the joint family properties which have been partitioned between the parties, is evident from page 24.
And as per the terms of settlement, this
And
C1
yes,
comes to the plaintiffs as per their shares.
and your lordship will see from page 30 that 6 Western Street has not gone to the other defendants at all. No part of 6 Western Street has gone to the other defendants, which is evident from page 30. 30, 32, etc. But I shall not trouble your lordship with that. My lord will take it from me and I shall take correction later on if it is so pointed out. This is not disputed. This is an admitted fact.
29. 29 C1.
Now this is, yes, C1. This took place in February 2016. 20th February 2016.
Yes.
Today, my lord, we are in 2025. Nothing has happened. And the preliminary decree was passed on the basis, my lord, of this family arrangement and family agreement, which incorporates therein the schedules, which makes specific allocation of 6 Western Street, Kolkata, to the plaintiffs.
So as per Annexure A, family settlement, you get this
6 Western
C1.
Street. Yes.
6 Western Street.
6 Western Street.
As per your shares.
Yes. Now, my lord will be pleased to come to page 55. It starts at page 52, but kindly come to page 55. This is the preliminary decree which was drawn up. There is no dispute about this, and nobody is really. Page 59 at the bottom, terms of settlement is recorded and ought to be carried out, and the same is ordered, and the interlocutory application being GA number so and so is disposed of accordingly.
30th day of December.
Page
in the year-
59.
Yes, yes, in the
Last 3-4 lines. The terms of settlement is incorporated in the preliminary decree. My lord has found it. It's handwritten.
of settlement be recorded and ought to be carried out.
Yes.
The same is ordered and the
Interlocutory
application is disposed
for
accordingly.
passing the preliminary decree,
Yes.
and the same is disposed of accordingly. So we
Yes.
have a situation where the parties enter into a family agreement. The family agreement mentions 4 properties. Out of the 4 properties, 1 is exclusively given to the plaintiffs. The allocation of the property is also sorted out, and a preliminary decree is passed in accordance with those terms of settlement, which is incorporated in the preliminary decree. Since nothing was happening, my lord, in the meantime, there have been many applications, many disputes, but if done in terms of settlement. Now kindly come to page 71. First is the cause title. This is the recent terms of settlement that has been drawn up by and between the plaintiffs, defendant number 1, defendant number 3, 4, and 5.
It's Annexure C.
Annexure C.
Yes.
Kindly see paragraph 4, page 76. My lord has got it.
Page 74.
76.
76.
74 and all is the cause title.
Yes, terms of settlement.
Presently, considering the fact of long pendency of the suit and taking into account that some of the parties to the suit is suffering from old age ailments, the plaintiffs and the defendant numbers 1, 3, 4, and 5, they are appearing before your lordship today, have agreed to their respective shares in Faraday House situated at 71 Bentinck Street, Kolkata, AC Mansion situated at 72 Bentinck Street, Kolkata, Bentinck House, etc., and Engineering Center situated at premises number 6, Western Street, Kolkata 1, which was already indicated in the family arrangement. So 6 Western Street is mentioned here. The parties further agree and record that such allocation of shares as expressly mentioned in the said family arrangement dated 20th February 2016 is acceptable to them, and they undertake to be bound by such agreement to the extent of their respective shares. The parties further undertake that they shall not dispute the said shares in the said properties in any manner whatsoever. The respective shares of the parties in premises number 71, 72, and 73 Bentinck Street and premises number 6 Western Street, along with all the common areas and common amenities and facilities, together with the tenants occupants presently occupying each portions, are separately indicated in the schedule hereto annexed and marked B. The parties have agreed that upon execution of the present terms of settlement and acceptance of the same, the parties shall immediately receive and or take possession of their respective areas and or shares of the aforementioned premises allotted to them under the family arrangement dated 20th February 2016. Particulars whereof are indicated in the schedule being marked in Annexure B, and will occupy the same through their tenants occupants as indicated in the said schedule, subject to the compliance of the obligations as mentioned in clause 10 hereafter. The parties further agree that none of them will interfere and disturb or dispute the possession and or allocation of areas of any of the other parties, and parties will have exclusive and unfettered rights in their respective portions of the aforementioned premises, which would include the right to collect rents, occupation charges from the concerned tenant occupant without interference of any nature from any of the other parties. Upon acceptance of the present terms of settlement by the parties, letters of atonement, letters of information shall be issued to each of the tenants mentioned in Annexure B, indicating thereby the ownership of the individual properties and particulars of the person who would collect rent, occupation charges as the owner thereof. The parties agree that it has been recorded in the family arrangement dated 20th February and also in Annexure B that premises number 6 Western Street, Kolkata, along with all the common areas and common amenities and facilities, will exclusively vest in favor of the plaintiffs, what I just showed to your lordship and submitted before your lordship. Upon execution and acceptance of the present terms of settlement, the parties and particularly the plaintiffs further agree that all dues, my lord, this is very important, to the Kolkata Municipal Corporation in respect of premises number 6 Western Street shall be borne exclusively by the plaintiffs. Minus this Kolkata municipal dues was posing a problem, a cog in the wheel. So we are saying we shall pay all outstanding dues of Kolkata Municipal Corporation insofar as Western Street property is concerned, shall alone remain exclusively liable for the same. And to this effect, the plaintiffs jointly and severally doth hereby indemnify the defendants. What more can I do?
No, this is page 79.
Page 79. So I shall pay all dues of 6 Western Street. I shall clear all arrear dues, go on paying future dues, and I shall indemnify the defendants of the same. The parties further agree that the plaintiffs shall in no manner whatsoever be responsible and liable for any of the liabilities in respect of 71, 72, and 73 Bentinck Street towards Kolkata Municipal Corporation. Naturally, because I'm not getting that property, or of any nature whatsoever, or the liabilities or of dues of any nature whatsoever in respect of AC estates. And to this effect, the defendants jointly and severally doth hereby
This is which
indemnify
paragraph? Para 9?
Internal page 9, page 79.
Yes, para?
The first para itself I'm reading.
No. This is
That is
page,
continuation of para 8.
This is continuation of para 8. No, the last 5 lines are the defendant number 1, 3, 4, and 5 hereby agree to vest their right, title, and interest in premises. Is it
paragraph? Page
page
78, come to paragraph 8 first.
Yes, the parties agree and it has been recorded in
Yes.
the family arrangement.
That premises number 6, my lord has found it, my lord.
Yes. Western Street.
Yes. Along with all the common areas and common amenities and facilities will exclusively vest in favor of the plaintiffs upon execution and acceptance of the present terms of settlement. The parties and particularly the plaintiffs further agree that all dues, this is a very crucial line, to the Kolkata Municipal Corporation in respect of premises number 6 Western Street shall be borne exclusively by the plaintiffs, and the plaintiffs shall alone remain exclusively liable for the same. And to this effect, the plaintiffs jointly and severally doth hereby indemnify the defendants. So they have no liability whatsoever. I'm taking over full responsibility of clearing off all arrear dues. The parties parties further agree that the plaintiffs shall, in no manner whatsoever, be responsible and liable for any of the liabilities in respect of premises number 71, 72, and 73 Bentinck Street towards Kolkata Municipal Corporation of any nature whatsoever, or the liabilities or of dues of any nature whatsoever in respect of AC estates, and to this effect, the defendants jointly and severally doth hereby indemnify the plaintiffs. The defendant numbers 1, 3, 4, and 5 hereby agree to vest their right, title, and interest to premises number 6, Western Street, solely and absolutely in favor of the plaintiffs, and none of them have any right, title, and interest in the said premises as Western Street. So they were not given any rights, and they make that even clearer. The defendant numbers 1, 3, 4, and 5. So 6 Western Street comes to me. Paragraph 9, my lord, refers similarly to the shares which were allocated towards the defendants in respect of the other 3 properties. And C1 is not mentioned in paragraph 9. If my lord wants, I can read out the entire paragraph.
This is paragraph 9.
Paragraph 9 of page 79.
Yes.
My lord has found it?
Yes.
The parties hereby agree, and it has been recorded in the family arrangement dated 20th February 2016, and categorically mentioned in Annexure B hereto, that premises number 71, 72, and 73 Bentinck Street, with exclusively vest in favor of the defendants in the suit, as per their respective shares mentioned in B2 to B5 and C2 to C5. C1 is not there. C1 is 6 Western Street. Of the family arrangement dated 20th February 2016, and also categorically mentioned in Annexure B of these terms of settlement. And the plaintiffs shall have no right, title, claim, or interest upon execution and acceptance of the present terms of settlement by the Honorable Court. The defendant numbers 1, 3, 4, and 5 also agree, and it is clarified that each of the said defendants would not have any right, title, claim, or interest in the allocated areas of any of the other defendants mentioned in the schedules B2, B5. So the other defendants' shares are also taken care of the family arrangement, and also categorically mentioned in Annexure B of this terms of settlement in premises number 71, 72, and 73. My lord, the defendant numbers, paragraph 10, the defendant numbers 1, 3, 4, and 5 shall, within the next 6 months from the date of acceptance of the present terms of settlement, make payment of their proportionate liabilities due in respect of 71, 72, and 73 Bentinck Street directly to such statutory authorities, namely the Kolkata Municipal Corporation, income tax, and the liabilities towards gratuity payment payable to the staff. And upon clearance of all the dues, the defendant numbers 1, 3, 4, and 5 will take possession of their respective shares. So they will also pay their share, which is due and payable to the statutory authorities.
With regard to the respective premises?
Yes, in respect of those premises of Bentinck Street, which are allocated to them. This is not Western Street, this is the Bentinck Street property.
Bentinck Street.
The plaintiffs shall, within the next 6 months from the date of acceptance of the present terms of settlement, make payment of their liabilities of the Kolkata Municipal Corporation. The defendants and plaintiffs shall not sell the properties up to 6 months from the date of acceptance of the present. Naturally, my lord, we impose a self-imposed embargo on us from selling the properties till all the dues of the statutory bodies are paid off. So that, my lord, the spirit
to sell the portion of the shares.
Yes. So that, my lord, the spirit of the original terms of settlement, the preliminary decree, and subsequently, my lord, the present terms of settlement is given effect to.
So preliminary decree was passed on the previous terms of settlement, former terms of settlement.
Yes. But since nothing is happening, these plaintiffs and these defendants are saying, kindly give us the properties which were allocated to us under the previous terms of settlement. We shall clear all outstanding dues of the statutory bodies in accordance with the previous terms of settlement. Let us walk out. Thereafter, what you do with your properties, whether you want to enjoy them, whether you want to sell them, whether you want to pay the statutory dues or not, is your problem. You make an application and decide, or you decide it amongst yourselves. My lord, will see page 81. The parties, the usual, nothing more. My lord, the defendant number 2 has filed an affidavit in opposition in these proceedings.
Yes. Affidavit in
Paragraph-
opposition to this application.
Yes. The application is by plaintiff D1, D3, D4, and D5, but the D2 has also filed an affidavit saying, my lord has found it, page 11 of the affidavit of
Opposition.
But the application is not by us. I believe, my lord.
No. I'm not saying that.
The affidavit, the opposition.
The application is by.
No.
We have signed the terms, but the application is not by.
I stand corrected. The application is by the
Application is by the plaintiffs.
by the plaintiffs. Only by the plaintiffs. Well, you're correct, Mr. Ghosh. Page 11.
Yes.
I am ready and willing to be part of the settlement.
No, page 11 of the opposition.
Of the opposition filed. I think the advocate is Mr. Farooq Ali.
This is by
the Costa.
Yes, Abu
Rashina Ahmed.
Yes, Hadia Abu Bakar.
No.
He's the deponent.
Rashina
6, 7, and 8. You have filed your affidavit in opposition.
That is the one before.
But I am first showing the affidavit filed by Rashina Ahmed. Defendant number 2.
Okay, give that.
Service affidavit in opposition by defendant number 2. Advocate on record is Farooq Ali. Kindly come to page 11 of this affidavit. My lord has found it, my lord.
Yes, just. Yes, Rashina Ahmed.
Yes.
That is defendant number 2.
2.
No, defendant number.
My lord has found page 11.
Page 11. No, I am considering by whom it is filed. Page 6.
Page 6.
The constituted attorney.
Of Mrs.
Yes,
Kani's
constituted
number
attorney.
2.
Yes.
Yes.
Yes, page 7.
Page 11.
Page 11. Yes.
I am ready and willing to be a part of the settlement if upon execution all parties will be handed possession of their respective shares regardless of any outstanding dues, or a special officer be appointed to collect the respective dues of the respective parties and shall allot possession to the respective parties immediately on payment of their dues. I am saying, my lord, I shall pay my dues in respect of Western Street property. So, my lord, if the others pay or do not pay, my lord, frankly speaking, should not be my concern. But the reason why I'm showing your lordship this paragraph is to show to your lordship that even the defendant number 2, who has not signed the subsequent terms of settlement, is agreeable to the settlement, provided she gets possession and provided, my lord, everybody pays their shares. If everybody, the reason why, my lord, I have made the application is because I am ready and willing to pay my shares. So why should I suffer? Why should I be kept out of possession, my lord, since 2016? So far as those 3 properties in Bentinck Street are concerned, it will be between the defendants who have been allotted those properties. Let them make appropriate application, and if my lord feels that my lord will give them any relief, my lord will give them the relief.
Defendant number 678 says they're ready and willing to pay municipal taxes to be a part of the settlement.
এটাতে
On my
দেখাচ্ছি. So my lord sees, so far as the defendant number 2 is concerned, there is
This position should be handed over.
no,
So-
but the point is,
So you are ready and willing to hand over, to forego the position?
I am not going to hand over possession. 6 Western Street should be given to me. And I'm not saying that I will take it without paying the outstanding statutory dues. I shall pay all the statutory dues. and
The question is all parties will be handed possession. That means in terms of she's a party to the terms of settlement.
No, not the subsequent terms of settlement. She's a party to the original terms of settlement. What I am saying,
How much she will get? Which portion she will get?
it is allocated. It is allocated.
No.
So far
You
as
have agreed amongst yourself
yes,
to take so and so portion.
my lord, I have no objection if she gets possession of her share in accordance.
No, definitely she has. But which portion? Because she's not a part of the second terms of settlement.
That is there. That is there.
So where is that provision regarding this defendant number 2?
Defendant number 2. Kindly grants me a moment. A petition to থাকবে. A petition to. Page
29. She gets 71 Bentinck Street, 25.9%.
This is the petition. এটা কি?
Petition. It's a page 20.
Just page 88. দাঁড়াও, let me find it out.
29 থেকে দেখানো সেম টেবিলটাই
Kindly go back to the petition, my lord.
Yes, your petition.
Yes. Kindly come to page 29, which I have placed before my lord so far as 6 Western Street is concerned.
Page 29.
Page 29. My lord remembers this page. I showed your lordship the
Yes.
bottom right hand for 6 Western Street. I was showing C1.
With your leave. My lord, I believe Mr. Bose is going to continue for some time. 12 o'clock, your lordship is going to take
Yes.
appellate side matters.
Yes.
Then, my lord, after hearing them, the other defendants who are opposing Mr. Bose,
So it will take some time.
yes,
Yes.
but kindly reserves my right to give reply after the other defendants who are opposing Mr. Bose. Your lordship can hear them, my lord. I'll just take your lordship's leave.
But my learned
There
friend
is 5 or 10 minutes left.
Yes.
No, I shall continue.
Let my learned friend continue. Let it be fixed any other day.
Oh, because
My
after
lordship-
12 I've kept some appellates and matters.
My lord, then my lord will keep it for another day. But may I just show this?
But you
particular-
clarify this position regarding,
I'm clarifying it right now.
Let Mr. Bose.
or on the next day, it would be advantageous if you come with some written suggestions or written.
Yes, yes, yes. We will prepare a written note. But let me just show your lordship
yes,
from
yes,
this.
yes.
Kindly
Just-
take
Kindly
page
fix this
29.
another day
Yes,
after Mr. Bose completes.
I just show this part and
Yes, yes, yes.
page 29. This is a
Yes.
chart which I've already shown,
Yes.
the allocation of the parties. I showed your lordship the bottom right-hand side, C1 regarding 6 Western Street.
Yes, bottom portion.
My lord was wanting to know what happens to the defendant number 2.
Yes.
Go to the top right-hand side.
Top
box.
right hand side.
He has allotted schedule C3, C/3,
Areas allotted schedule C3 to party of third part.
Kanis Fatima.
And party of third part is Kanis Fatima.
Anyway, that
The
means
defendant number 2.
defendant number 2, although she's not a privy, but she's a beneficiary of.
Yes,
This
and I
type of
have no
settlement.
objection if she gets her possession. But the point is she has to pay the statutory dues in respect of that particular building.
How much is the statutory dues?
That is,
Is it there mentioned?
well, that is perhaps not even your lordship's domain, my lord, at this stage to go into. Because I am saying that I am not stretching my hands into your properties. I am going by the undisputed fact that 6 Western Street has been given to me.
So that means she is ready and willing as per the to
That
this
is the
portion.
only reason why I showed your lordship that paragraph, that she also, though she has not signed the subsequent terms of settlement, is ready and willing to abide by a settlement, provided she gets possession. Let her take possession. How she will sort out the payment of the statutory dues in respect of her portion of the property, which is by and between those defendants who've been allotted that. I am not interfering or even encroaching upon their property.
No, is it a conditional acceptance as per the affidavit in opposition?
Well,
That is the question.
But the point is, how does it matter? How does it matter whether it's conditional or not? When I am not touching your property, the original terms of settlement remain, the original preliminary decree remains from 2016. Parties have dilly-dallied and have not, my lord,
It is
given
the
effect.
only, as because she was, although she's a beneficiary of the settlement, but she not
My
being
lord,
a
I tell
party.
your lordship, she is a beneficiary. She says, give me possession, but I will not pay any statutory dues.
But the question is, you see,
But that can't be done.
no,
So that is for her to sort out with the other defendants.
question is, we cannot be any agreement to contravene any provisions of the statute. There cannot be any agreement.
And more so the contravention of the any clause of the original terms of settlement which culminated in the preliminary decree. So because, my lord, I am saying you leave the rest of the properties. You fight amongst yourselves till times immemorial. Not times immemorial, till the future day. But I want to walk out after paying all dues. And there is no embargo on that.
She has not given any other counter suggestions that apart from that, I shall take.
She has not made any application unless if she wants any relief from your lordship, she has to make an application. She has not made any application. She has filed an affidavit. The only reason for pointing out that affidavit is to show that she herself is not opposed to any form of settlement. But she says, provided everybody pays their dues. You get your group to pay your dues and you take possession of your property. I have no objection. You otherwise take possession of your property if you can arrange some other way with your other co-defendants. That is entirely up to you. I shall also show, my lord, the affidavit filed by the group of defendants who are the only people who are opposing this to demonstrate to your lordship that there is no substance therein. And this is a matter where your lordship will be pleased.
The affidavit you filed your reply also. You have dealt with that paragraph.
Everything is ready. I don't want to. Everything will be decided on the
Defendant
basis
number 2 has filed the affidavit in opposition. Others have not.
6, 7, 8.
Yes, 6, 7, 8 have.
And you have also filed your reply. Then,
Everything.
Then you have to deal with them. You have to deal with them and clarify.
On the next day, I will the next day.
Dispute the terms of settlement.
They do not dispute the terms of settlement. Well, kindly fix a date. I shall conclude my submissions that day. It's a very simple matter. Well, kindly make it as soon as possible so that everything is fresh in your lordship's mind.
Yes.
And my lord, the persons concerned, my clients, they're all very aged people. They want to see, my lord, the end of this litigation, which has been continuing for so long, and my lord, so much money and heartbreak has gone into it. So
from 2016, 2012.
10. My lord, kindly fix a date any day next week.
Yes. Learned, Mr. Basu, learned counsel for the plaintiff, submits on.
Well, I'm Mr. Bose, my lord, not Basu.
Mr. Bose, learned counsel for the plaintiff, submits on GA 8 of 2025, but could not conclude his submissions. Let this matter appear on Four 7/2025 at 11 a.m. I'm keeping it on a Friday.
Very well.
At 11 a.m.
Very well. Entirely up to your lordship's pleasure. Well, it is not possible to do it a little before 4th.
Next week, you see, 1 or 2 days, there is some uncertainty whether this bench will sit or not for 1 or 2 days.
It's fine. It's fine.
That is why, to be on the safe side, I'm
very grateful.
Kept it on Friday at 11 a.m.
I'm very grateful.
And Friday also, in the second half or after 12, appellate side or division bench.
I shall, if my lord takes it at 11, I shall definitely finish it that day.
Yes.
I'm very grateful to my lord. Grateful.
Huh? The original side? No, but appellate side matter. No. আচ্ছা যেটা ফর অর্ডারস হলো না আজকে না ওটা একটা তো টু বি মেনশনে আছে অর্ডার ছিল বলো আচ্ছা ঠিক আছে একদিন চেম্বারে আজকে যেটা ছিল টু বি মেনশন ঠিক আছে মিটে গেল আর ফর অর্ডারসে যেটা 4 নম্বর আছে ওটা আবার টু বি মেনশনে গেল সাপ্লিমেন্টারি শৈলী ঘোষ। আচ্ছা এইটা
কপি পাইনি, এটা কি করবো?
লাস্টে এটা তো ফরওয়ার্ডার্স হলো। ঠিক আছে, একটু দেখে শুনে তো সব নোটিশ অফ মোশন টোশন সব দেখে টেকে, আর যেগুলো ফরওয়ার্ডার্স আছে আমাকে একটু জানাবেন একটা লিস্ট দিয়ে।
এখনো হয়নি।
আর এবং সেইগুলো রেকর্ড গুলো যখন যাবে সব থেকে নেবেন, সবগুলো যাচ্ছে কি।
হ্যাঁ অ্যাপিলেট সাহেব আপনি আছেন?
একটু দেখে
হ্যাঁ উনি
একটু ক্লারিফাই করে দেবেন। এটা তো নোটিশ অফ মোশনটা তাহলে কিছু ওইটা লিখে দিলাম, নোটিশ অফ মোশন বি কেপ্ট উইথ দ্য রেকর্ড।
না উনি পিটিশন, আপনারা
যদি না থাকে ওই অর্ডারটা তাহলে আমি কবে পরে বিকেলের দিকে সাইন করবো বা সোমবারে।
উনি
ঠিক
দাদা
আছে, তাহলে
আছেন
পরে ওটাকে
পিটিশনের হয়ে, আমি হচ্ছি
যেটা ইয়ে হলো এটাকে একটু পাঠিয়ে দেবেন, ওই যে একটা ম্যাটার হলো না,
তো আমাদের
না,
নিজেদের
ওই যে যেটাতে ওই যে কস্ট হলো 1700, এটাকে অন্তত আগে পাঠিয়ে দেবেন।
ফিস পেলে
ঠিক আছে।
That before your lordship calls the appellate side matter,
Yes,
item number 8 in the original side, it'll take only 30 seconds, my lord.
30 seconds for what purpose?
My lord, there's a restoration application which is with a delay of 2,200 days.
So give me some time also.
No, my lord, I am for the respondent.
Oh, you are for
For
the.
the respondent, I will be, my lord, a copy has not been served on the respondent number 1.
Okay. Who is for the petitioner?
I am for the petition.
So if a copy is just served on me, I'll file an affidavit and cover.
GA3.
It's my
Okay, item number 8, record and order.
Just a copy will be served to the
Yes,
respondent number 1.
But she have filed the opposition, but no reply has been filed.
anyway, learned advocate for the petitioner and learned advocate for the.
We are supposed to also file the supplementary affidavit. So we are
You
also.
serve both on me.
Yes, I
And for opposite party number?
Respondent number 1
Okay, learned advocate for the petitioner and learned advocate for the respondent number 1 are present.
and 3.
Learned advocate for the petitioner, learned advocate for the respondent number 1 and learned advocate for respondent number 3 are present. Let the supplementary affidavit file be kept with the record. Let copy of the application be served.
And the supplementary affidavit.
Copy of the application and supplementary affidavit be served upon the learned advocates for the respondents.
My lord.
Let this matter appear.
Lordship will give me 3 weeks to file an affidavit to this. My lord. I will file an affidavit.
My
to
lord, I believe that this affidavit has now become infructuous since he has appeared. This was on
No,
the
I'll
point
give
of
an affidavit
service
to the application.
Opposition.
or application, right?
Let this matter appear on 9. Okay, let this matter appear on. Yes, 9/7/2025.
9th of July.
9th of July.
9th of July.
Well, I will take a little more time to file my affidavit. My lord. Lordship will give me 3 weeks. My lord.
Okay.
Till that's the 11th.
16/7.
Yes.
2025. Affidavits must be completed in the meantime.
I'll give it by the 11th. I'll give him a copy.
My lord.
They has not also filed the affidavit. Opposition has been.
Grants me.
I have granted the opportunity. Affidavits must be completed in the meantime.
My lord.
ঠিক আছে?
My lord.
Grateful.
না 9 5 এসছে ভাই আমার ফাইল করেছি 5 তারিখে পাঠিয়েছি
সইটা করতে আগে ওইটা কি একটা পুট আপ হলো না, সইটা করে দিচ্ছে ডিভিশন বেঞ্চের একটা সই করতে হবে। ওখানে পুট আপ করবে।
আপনি এটা নিয়ে কপিটা নিয়ে রিসিভ কপি করে দিন না, তাহলে তো
হ্যাঁ হয়ে গেল
কাজে গিয়ে
এগিয়ে যায়
ঠিক আছে। কেউ কাটতে হবে।
Yes, call the appellate side matters.
Milord, in this matter, Milord, argument is already completed. Learned advocate appearing for the petitioner is Milord, my learned friend senior. He has also submitted his written notes of argument on the last occasion. Today, Milord, I am submitting the written notes of argument. I am for the opposite party. I have given him a copy.
Yes, learned advocates for the
Opposite party.
learned advocate for the opposite parties are learned advocates for the parties are present. Let written notes of arguments filed by learned advocate for the opposite parties be kept with the record and copy be served.
Copy we have already served.
Copy is already served. Hearing of this case is concluded. CAV.
I'm grateful.
আচ্ছা এগুলো আছে কিনা একটু দেখে নেব, ওই আগের রিটেন নোটস অফ আর্গুমেন্টস গুলো আছে তো এর মধ্যে ফাইলে?
আগে একটাই এই অনলি ওয়ান
পিটিশনারের গুলো আর
পিটিশনার। আপনি তুলুন, আমি বলে দিচ্ছি তুলুন তুলুন তুলুন, ওটা না ওইটা 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 এইটা Milord, that is Milord the written argument submitted by my learned friend senior, and today we are submitting written argument.
yes CAB.
I'm grateful.
Item number 2, matter is sent to the mediation.
Let me see the
opposite party number 5. Opposite party.
let me see the record. Is this matter a parted matter?
No, that is sent to the mediation.
No, very well. If it is not a parted matter, I have to release this matter.
No, that is not a parted matter.
Then I have to release this matter.
My lord, may I bring to your lordship this
Yes.
that my lord had sent this matter for mediation.
Yes.
On 2 occasions of the mediation, the petitioner husband did not appear personally, my lord.
No.
Whereas,
Nothing.
my lord,
The report has not come.
Yes, that is not a
Mediator
parted-
has not given. Anyway, even if the mediator submits his report, as because this matter is not parted, I cannot take up this matter. Okay. So I have to release this matter. Let it be placed before the bench.
But my lord, may I pray for one indulgence?
Yes.
Is that the opposite party wife is suffering, my lord.
Yes.
My lord, the petition husband is not clear whether he is accepting wife or he is ready to pay maintenance.
But I cannot pass any orders. You see, this is because I was of the impression that it is a parted matter because I heard this matter.
Yes,
But anyway, this is not a parted matter. So I have to release this matter. Yes. Learned advocates for the parties are present. As this court does not have determination, let it go out of the list and be placed before the appropriate bench.
Grateful.
Lord, same Lord, I'm thinking short Passover is arguing a matter, Mr. Mukherjee, Tanmoy Mukherjee.
Okay, short Passover, but I don't know whether it can be taken up after Passover. Anyway, short Passover.
Occasion it has been adjourned.
Yes, yes.
Anyway, let us see, wait for some time.
Number 4.
Yes, 4. Yes, Passover.
Number 5.
At 5 and 6, both the matters I beg to appear for the petitioner, my lord.
My lord, I am for the private respondent number 6.
There was a direction upon them to file their opposition, my lord.
My lord,
I will seek, they have served me with an advance copy, my lord. I will seek 1 week or 2 weeks time, my lord, to file it, my lord.
my lord,
5 and 6, both the matters.
Both the matters, and another thing, my
another
lord.
matter is also
Another matter is also there, my lord, pertaining to same case, my lord. 3 matters. 1, 5 and 6 is the petitioner is the husband, and there is another matter. And I have written the number, my lord.
5, 6.
Yes, my lord.
Yes,
No,
my
no,
lord.
is the other matter assigned before this?
Yes, yes.
yes,
All
sir.
the 3 matters
Three
has
matters have
been
been
assigned to your lordship, my lord. And on the last occasion, when my lord has passed the order, my lord, 3 matters my lord has passed with regard
With regard to the other matters, you may hand over the slip. Okay.
my lord.
Let me pass orders in these 2 matters.
My lord.
If
my
that matter is assigned, you may hand over the slip.
lord. I have given the name, a number of the to my lord's officer. My lord.
Yes, record an order.
But I shall file the affidavit in opposition, my lord.
Yes,
In
learned
respect of-
advocates for the petitioner and learned
Which is
advocate for the
2724.
opposite parties. Yes, state is present.
Yes, my lord, I am.
My lord,
State has filed opposition.
state was
No,
directed
my
to
lord,
give case diary.
respondent.
Okay.
It was directed to bring
Learned advocate for the
No.
I'm appealing.
on the last occasion, sir. That was the direction.
In this case, before this court, no.
Yes,
Got the case diary, Xerox copy of the case diary.
case diary was recorded, sir.
Hey,
okay, produce it on the next day.
shall I submit?
No, case diary with regard to the case, particular reference.
My lord, my lord.
27605. Sure.
Okay, file it on the next day. I am adjourning this case. Okay.
My lord, my lord.
Learned advocate for the petitioner and learned advocate for the opposite parties are present. Affidavit in opposition filed by
Another private respondent, my lord.
yes, respondent number
5, 6.
One is,
Six.
yes, my lord, Tumpa Mal, my lord, in respect to my lord, first matter, my lord, respondent number 6, and in respect of second matter, my lord, that is 6, item number 6, that is, my lord, 5.
The same person, my lord.
Same
Item
person,
number
my
5 করবেন, respondent number 6 be kept with the record.
And my lord,
Petitioner is granted liberty to file affidavit in reply on or before 4th July
My lord.
2025.
My lord.
Let this matter appear on 4/7/2025.
Grateful, lordship.
Acha, item 6 yes, item 6 you are responsible.
I'm appearing in 5.
my lord, item 6, I am for the respondent number 5. And in respect of
করে দেবেন,
এটা দিন
ওটা 6 আছে, এটা respondent number 5
5
হবে।
and 5, my respondent number 6.
Yes. You are for respondent number 6.
My lord, I'm for
State
the
respondent.
state respondent, my lord.
In item number 6, my learned senior.
Yes, item number 6 আরেকটা ইয়ে করে দেবেন লাইন, let the case diary be produced on the date fixed.
My lord.
My lord,
I'm representing 3, 4.
Yes, state.
And 1, 2.
washing of FIR,
4. State.
read petition file,
that
my
is
lord,
why I'm
washing of
saying,
FIR
Let's submit.
in respect to a murder case, my lord.
My lord, let it be.
No, I'm not going into the merit. I will
Okay.
beseech my learned friend
Item
not to get into the.
Item 6 এ করে, is it Xerox? Is it Xerox? Okay, then it's okay. Item 6 এ করে দিন, let the case diary filed be kept with the record.
My lord,
By the
the same case diary is required in item number 5 also, my lord, because it's
That-
pertaining to the same,
That I shall consider on the next day.
Only regarding item number 6.
pertaining to same case, my lord.
Yes, it will appear on 4th. If you file your affidavit in reply.
My lord, I shall, my lord.
Copy in advance.
4th July, my lord.
Yes, yes. Serve copies also.
My lord, I shall definitely, my lord.
Record.
No, have you received opposition? No.
Opposition.
Yes, yes, my lord, I'm submitting.
Opposition, my lord, I have received, my lord. I have.
কত এটা দাঁড়ান দিচ্ছি। আপনি কত নম্বরে আছেন?
দিদি 6 আছে।
5 স্যার দাঁড়ান।
And my lord, affidavit reply to be served.
I shall.
Not necessary. They will
I
give.
shall, definitely. I shall.
দুটোতেই একটা ইয়ে করে দেবেন, the copies of the দুটোতেই copies of the affidavit in reply shall be served upon the respondent.
স্যার ওইটা ওটা দিচ্ছি স্যার। ওটা আপনি
দুটোতেই 5 আর 6 দুটোতেই
24 স্যার এইটা ম্যাডাম দিদি এইটা আমার অপোজিশন
এই নিন ভাই।
আরেকটা দিন আমার জুনিয়রকে। আরেকটা জুনিয়রকে।
দিদি একটাই তো কপি আছে আপনার।
তাহলে একটা কপি ওকে দিয়ে দেবেন না কপি।
এটা থেকে করে নেব। এরপর দেবো কেন দাদা? আপনাকে দিচ্ছি আবার।
Grateful.
But when my lord it has been fixed on
Deeply obliged.
4th July.
4th July.
Lord, I beg to appear for the petitioner revisionist. My
Yes,
lord,
you are required to file one application.
yes, what has happened, my lord? One of the opposite parties has died,
Yes,
and my lord, his heirs have been duly substituted before the learned trial court.
yes.
Now, despite that, my lord, I have taken out an application for substitution, and I have served the copy upon my learned senior friend.
This is can 1.
Yes.
Substitution be allowed and substituted respondents be served. Otherwise, I am not appearing on the substituted respondent.
Yes, record an order. Yes, what is this application?
My lord, can 1.
Give the can application.
A can to the
Item 7.
7.
Can application. এটা দেখুন তো
এটা
কোথায় আছে।
এটা দেখি করে দেখ। কোটে ভাই আছে। প্রতিদিন করতে পারেন।
Your lordship, I have the application.
Yes, let me see just a
The photocopy, my lord, I have.
আসেনি নাকি? No, when did you file application?
My lord, it was filed this week on 17th of June 2025.
17, 18, 19.
This is the photocopy.
আনিয়ে নেবেন তো ওটাকে, আমি এটার উপর ইয়ে করছি। আচ্ছা, learned advocate for the petitioner and learned advocate for the opposite party number 1 to 8 are present.
One has died.
One is there.
Anyway, but still he's holding the power
Yes.
unless deleted.
Deleted.
The petitioner has filed one application, Can 1 of 2025, for substituting the legal heirs of the opposite party number 1, Vishwajit Mondol,
Yes.
who died on.
No, Shochipada Mondol.
Oh, one is this. Just a minute.
Vishwajit Mondol.
Okay, sorry. Opposite party number 1, Shochipada Mondol, who died on October 6, 2024. Upon hearing the learned advocates, this court is of the view that, yes, you have filed it after 150 days, 78
Yes,
days.
I have filed this after 150 days here, but in the trial court, my lord, on 24th of February, my lord, this application was allowed.
Okay. Upon hearing the learned advocates and upon producing the petition, this court is of the view that delay filed in this application should be condoned, and the legal heirs of deceased opposite party number 1 should be substituted. Thus, the name of opposite party number 1, Shochipada Mondol, be deleted from the cause title, and the name of Bijola Mondol, Ashok Kumar Mondol, Ashit Kumar Mondol, Chobirani Pan, and Champa Mondol be substituted in place and stead of Shochipada Mondol. The department is directed to take necessary steps to cause the necessary amendment in the cause title. Stop. Let notice be issued upon the legal heirs of Shochipada Mondol. Let this matter appear on 11/7.
Yes, 11th of July. Only one thing, ma'am, may I serve upon the learned advocate appearing for the in the trial court also,
Okay.
because they are represented.
11/7, 2025. Learned advocacy is granted liberty to serve the advocate appearing for the substituted opposite parties in the trial court.
Yes. Both of advocate and this.
Yes, that is there, but additional.
Yes.
Additional.
Hi.
No, can is disposed.
Yes.
Can is disposed.
আপাতত ফাইলে রাখুন আর কি।
Item number 8, Your Lordship, Mr. Shonak Bhattacharya is appearing on behalf of the petitioner, praying for short passover, Your Lordship. Engaged in courtroom number 25.
He's for the petitioner.
He's for the petitioner.
On the last occasion, he had almost concluded. But may I just set out what is my arguments in the meantime?
You have prepared your written notes of arguments? Okay, prepare it on the next day. I'm just making it not today.
It will appear on the next Friday.
Yes.
Great.
As and when this court sits.
Great.
Better is continuing.
Okay, not today.
Why?
I'm just making it not today. On the next day, as and when the court sits, it will be taken up.
Record because.
Oh, that you are
because-
present.
Yes.
Yes, record and order. Mr. Banerjee, learned counsel for the opposite party is present. A prayer for time is made on behalf of learned advocate for the petitioner. In the interest of justice, the case stands adjourned till stop. Let this matter appear on 4/7/2025. Yes, but on the next day you should come ready.
On 4th, my lord.
Yes.
Twice it has been done.
Yes. Next day you must come ready.
To do the matter, my lord, later, because already very simple matter, my lord. 2000 an allotment letter has been given.
On the next day, you can do one thing, come with your short notes and conclude the matter.
Well, there cannot be any declaration of the contracts.
Yes.
He is asking for declaration. Specific performance he cannot ask. 3 years has gone from 2020.
So at best
2021.
he has to amend the plaint.
Why not? He cannot ask for now. He has asked for the declaration. But in contractual jobs, but a contract, your lordship knows in section 40.
Only damages.
Only he cannot ask for this declaration.
Okay. That you have
This is a
have a
small
liberty to take
but
this.
that is why I'm
No, you have a liberty to file order 7 rule 11 on the ground of maintainability.
Well, they are coming against the interim order which has been refused by the Asansol court.
By the district judge.
By district judge. Now he is coming here asking for to execute the thing which has been done in 2000. Out of which, my lord, of one acre land has been allotted. Out of which he has only
Anyway, on the next day, you see, even if they don't come, I shall hear your arguments and your written notes. At least I shall hear you and consider your written notes. Yes. Yes, item 4. 4 क्यों नहीं?
Already record some submissions were made, my lord.
No, Mr. I have recorded your presence.
I'm good.
Item 4. Okay, not today. You notice a motion? এটা যেটা 1700 মানে ওই 100 জেমস যেটা করা হলো ওই পেপারটা পাঠিয়েছে মানে ওদের ওই পিটিশনটা ঠিক আছে পাঠিয়ে দিন একটু ওই পিটিশনের কপিটা আর ওই অর্ডার শিটটা তাহলে দুটো আমি দেখে তারপর করবো
করবে না